Administration here in Minnesota. We will be starting our presentation today on contract performance for small businesses in just a moment. I would like to remind everybody that we are recording today's session, so we will be able to provide this to the University of Minnesota for future use. I would like to introduce Emily Buchholz to do the introduction.
Great, thanks, Mike. So I see that we have a small group today, and I see that there are some attorneys on the call, which is kind of interesting and exciting to see. Welcome. Thank you so much for being with us here today. My name is Emily Buchholz. I am the Executive Director of the Corporate Institute at the University of Minnesota Law School. The biggest chunk of what I do there is to teach and run the business law clinic. And I'm also a licensed business attorney. I have worked with small businesses for a number of years, and it's a practice area near and dear to my heart. So I'm really excited that we've been able to partner with the Small Business Administration this summer. This is actually part of a series of talks. The Small Business Administration has put on a number of talks with a number of experts who have come in to present. We have done a series. This is the fourth of four. So the first was on insurance claims, the second on lease issues, the third on unemployment benefits, and then today's talk on contract performances, all through the lens of small businesses. The other presentations were recorded, just like this one is being recorded. They are available on YouTube. So if you're interested in seeing one of those talks that you maybe didn't get a chance to join us for, you can go onto YouTube, you can search for UMN Law, or you can go to the Corporate Institute webpage. And I'll go ahead and put that in the chat bar in just a minute. You can hyperlink to all of the presentations from that page. All right, so you know, at the beginning of these talks, we always have to say that this is general information only. It is not the same thing as specific legal advice. So to the extent that you are, you know, have questions about your particular situation, really what you'll need to do is get connected with an attorney who can learn more about the nuances and context of whatever's going on for you to give you some specific advice to help you set expectations. But today's conversation is going to be really good general information to kind of talk about this area of the law and the lay of the land in this space. As Mike mentioned, you can put any questions that you may have in the chat bar. I will be moderating the discussion. I will go ahead and keep my eyes on that chat bar. I may respond to you directly. I may pause and ask the panelists to kind of chime in to see if they have anything that they might want to add. And we might also save some of the questions until the end. So no worries, if you have a question, go ahead and put it in the chat bar, and we'll try to get to all of them before we're done. All right, so I'm really excited about the panelists that we have. And actually, Mike, I just got a message from one of the panelists who said he's waiting to be let into the presentation.
Okay, I will see what I can try to do, but I believe he may be in the wrong presentation because everybody should not have been asked to be in. If you can just have him email me at don.jackson@sba.gov, yep, I'll be able to provide assistance.
Okay, sounds great. So I'm going to introduce the panelist who will be with us shortly. He is a wonderful professor at the law school. His name is John Matheson. He is a business and corporate professor and practitioner. He has won the teaching award at the law school something like 5 times because law students and alumni alike really enjoy taking his classes and working with him. We are delighted to have him here with us today. We also have attorney Joe Schauer, who is a graduate of the law school and is now a shareholder at Fredrikson Byron. Joe's practice includes mergers and acquisition work and securities work, but he also counsels businesses with kind of a general corporate framework. So we're really excited that he's willing to be with us here today as well. Finally, we have the 2 law students who have prepared this presentation for you and will be giving the presentation to you. They are our Corporate Institute practice scholars. So we have Jennifer Satterfield, who's a 3rd-year law student, and Shane Sanford, who's also a 3rd-year law student. Jennifer and Shane took the business law clinic with me last year, and they also took advanced corporate law with Professor Matheson. So we are delighted that they have been willing to give their time and attention and efforts to this presentation today. And without further ado, I will go ahead and turn things over to Jennifer and Shane.
Thank you, Emily. Whenever the presentation's ready to move, we can probably go to the 3rd slide. Okay, so our presentation is going to start off with entering into an agreement. We will be going over what constitutes the agreement and what laws might apply. Then we will review your potential options when a party can't perform under the contract, including renegotiation and litigation. Finally, we'll end with some practical tips, policy considerations, and resources. Next slide, please. So we're starting off with contract basics. Next slide. Okay, so how do you create a contract? There are 3 essential elements to create a valid contract: offer, acceptance, consideration. Okay, so what does that look like? Say I offer you $10 to rake the leaves in my yard and you accept. We have the offer from me, your acceptance, and the $10 is the consideration. Now, consideration does not have to only be monetary. It can be anything of value exchanged between the parties. So maybe instead of the $10, I offer to walk your dog in exchange for raking the leaves in my yard. That would still be valid consideration. It's also important to note that contracts can be oral or written, though there are some contracts that must be in writing to be valid under the Statute of Frauds, which I will address later. And I'd also like to point out that informal contracts can still be valid. An example of this is what we call napkin contracts. 2 people might hash out a business deal in a restaurant and write it all on a napkin. If there's offer, acceptance, consideration, it's still a binding contract. Next slide, please. So something important to consider from the get-go is how courts are going to interpret your contract. One way is by something we call common law. Common law is law derived from judicial precedent. So what the heck does that mean in plain English? There are certain principles or rules that courts will apply to interpret contracts or resolve disputes involving contracts. And these rules were not created by a legislature, but rather have been developed over a long history of cases. Next slide. Courts are also guided by statutes, and statutes are the actual written law created by legislatures. An example would just be the Minnesota statutes. One particular statute that applies to contracts is something we will refer to as the UCC. The UCC only applies to the sale of goods, which are defined as movable objects. Hence, there are some differences between the UCC and common law as it applies to contracts, which you will see throughout this presentation. And finally, courts will also use common law to interpret statutes. I know that's where it gets kind of crazy, particularly if a statute is ambiguous. So a great example of this is a statute that bans vehicles in parks. Is a bicycle a vehicle? A court will use common law principles to make this determination. Next slide, please. Another important rule is something called the four corners or parole evidence rule. So it's important to consider what a court will look at to interpret the contract you've created. In general, the court will only look at the four corners, kind of literally, of the written contract. If you discussed anything before this written contract that isn't captured in the writing, a court will not consider it, with some exceptions such as fraud or if the written contract is not the entire agreement. And it's also important to note this rule does not apply to any subsequent modifications. So if you renegotiate the contract, this rule does not apply. Next slide, please. Finally, I'm going to take you back around to the Statute of Frauds. So under the UCC version of this, Contracts for goods worth $500 or more must be in writing with the signatures of both parties. An oral contract won't cut it. Now, there are some exceptions, including contracts for business-to-business goods, specially manufactured goods, if a party admits that there's a contract, or if payment has already been accepted or the goods were already received. For all other types of contracts, Section 513.01 applies. So there are several scenarios where a written contract is required under this statute, but the one most applicable to a small business is contracts that cannot be performed within 1 year. Now, this does not mean the contract has to be completed within 1 year, but rather that it's possible it can be completed within a year. So, for example, an oral contract for a basic bathroom renovation. It's enforceable because even if the renovation takes 2 years to actually complete, it could reasonably be completed within 1 year. Next slide, please. Okay, so a party can't perform. What are your options? The first one I'd like to discuss is renegotiation. Next slide, please. So why renegotiate? First, modifying a contract is a great middle ground between being stuck with current obligations and trying to get out of them completely. It also maintains the business relationship with the other party. Just remember, stay cordial and professional to ensure that the business relationship doesn't go sour. Finally, litigation is expensive and time-consuming. The cost of litigation may very well outweigh the cost of just modifying the contract, and litigation will likely take up a lot of your just time and energy. Next slide, please. Now, you're probably wondering, how can I validly renegotiate the contract? Well, there are 3 possible ways. The first way is through something called consideration, where each party gives up something. An example of this may be a tenant that can't afford rent due to the current circumstances. Now, let's say the landlord normally takes care of plowing the parking lot in the winter. The landlord may be willing to reduce the rent in exchange for the tenant taking over the snow plowing duties. So they've both kind of given up something here. Another option is rescission, where the parties just completely terminate the contract and start a new one. Next slide, please. Finally, you may be able to actually modify the contract without consideration. If there are unanticipated circumstances, you can modify the contract so long as it is fair and equitable. Here, the unanticipated circumstance would be COVID-19. If you come up with a fair and equitable modification, it will likely be valid and upheld. Also, under the UCC, so contracts for the sale of goods, you can simply renegotiate and modify the contract. No consideration is necessary to do so. Next slide, please. So one thing to watch out for is a no oral modifications clause. It's pretty common, it's a boilerplate term, and it basically requires any subsequent modifications to the contract to be in writing and usually signed by the parties. But even if your contract doesn't have this clause, it's still important to get any modifications in writing in case of a future dispute. A writing leaves a paper trail and can avoid a he said, she said argument down the road. Next slide, please. Okay, so any questions, Emily? Or are we still chugging along?
Sorry, thanks. Yes, I did want to just pause and say welcome to the 2 panelists who it took a few minutes to get them on, but John and Joe are both on the call with us today, so welcome to them. And I wanted to just check in. Joe, I don't know how much of that first piece of the presentation that you caught, but was there anything else that you wanted to add in terms of background information about contracts or renegotiating?
Yeah, thanks, Emily. Glad I could be here. Sorry about my technical issue getting in. I think the point that Jennifer brought up, that renegotiating and working with the other party is often the most efficient way to work through these issues. And I think we have now we have a very unique circumstance with this pandemic that's creating so many issues for so many business owners. Unlike other instances or other events that have happened, probably in the last decade or so, this is really universally affecting everyone in some way, some significantly worse than others. But what we're seeing from a practical standpoint is that most parties understand, and because they're dealing with it even a business that is able to sell products because they help healthcare, those types of things, they're dealing with issues with employees and making sure they can stay safe at work, and how can they bring them in? How can they get supply? How can they sell their products and do it safely and in accordance with all these government orders and emergency activities that are being implemented? And so there's been a willingness, generally speaking, more than you typically see on when contract issues come up, for the parties to work together. Now, that's not universal, but if you're willing to try to, depending on which side of you're on, if you're willing to try to come to something that makes sense, and perhaps you just agree to it for a temporary period of time, or you reassess it every quarter or 6 months or whatever it needs to be, parties are making progress that way in sort of an efficient manner versus threats of litigation and those types of things.
Yeah, thank you for that. I think that's good kind of background and context too for how parties are thinking about this in terms of moving forward. Okay, Jennifer, why don't you take us through litigation, and then we'll pause again.
Okay, thank you. So renegotiation didn't work or isn't the option you want to take. What comes next? Well, the other option is litigation. Next slide, please. So there are 3 ways we're going to discuss that you can use to legally get out of your duty to perform under the contract, so discharging your duty to perform. Number 1 is the force majeure clause. Number 2 is commercial impracticability. And number 3 is frustration of purpose. Next slide. But first, there are a few things I want to address. It's important to know the statute of limitations that might apply to your case. Under the UCC, so contracts for the sale of goods, you must commence an action for a breach of contract within 4 years. And for other contracts, you have 6 years. Next slide, please. I'd also like to point out there may be several relevant clauses regarding your duty to perform under the contract, potential remedies, damages, etc. These clauses are going to be detailed in the accompanying handout, and I'm not sure if you got that ahead of time or if there's going to be a link, but there's definitely a handout available. And my focus today will just be on the force majeure clause. Next slide, please. Okay, so what is a force majeure clause? It's a clause in your contract that can relieve a party of their contractual duties if certain listed circumstances are met. Now, these circumstances may include acts of God, epidemic or pandemic, regional or national emergency, government action or order, etc. Could be a long list, it could be a short list. They also might contain catch-all terms, such as or any other like event, or any other event beyond reasonable control of the party. That kind of tries to reach beyond just the list. But it's important to note that this is derived from the contract itself. So it has to be written in the contract to apply. If you don't have a force majeure clause, you don't have a force majeure clause. Next slide, please. So next, I'd like to discuss how Minnesota courts interpret this clause. Courts will look at the language of the force majeure clause to determine if performance can be excused. Now, these clauses are narrowly construed, which means that courts will limit them as much as possible. So a great example of this is a 2002 Minnesota Court of Appeals case involving the Twins. So back then, the MLB was actually about to drop the Twins from their league, and the Twins had a contract to play in the Metrodome. Well, if they're no longer going to be an MLB team, they had no reason to play games in the Metrodome. So they were trying to get out of this contract based on the force majeure clause. Unfortunately for the Twins, the court held that they had to continue playing in the Metrodome because a contract with the MLB was not one of the listed terms in the force majeure clause, which only referenced strikes, an act of God, a natural casualty, or a court order. So being dropped from the MLB wasn't part of this. Twins were out of luck. However, the MLB thankfully abandoned their plan to drop the Twins, so it all worked out in the end. Next slide, please. So I'd like to address some other important points. There is a causation requirement to utilize the force majeure clause. So the triggering event, like an act of God, must be serious enough to interfere materially with the performance. If you can still perform under the contract despite COVID-19, then you probably can't use the force majeure clause to get out of performing. Next slide, please. So another important point is foreseeability. So the triggering event, like an act of God, had to be out of your control, and it had to be reasonably unforeseeable. Or if it was foreseeable, you have to consider whether it was could have been prevented or its effects mitigated. Next slide, please. Which leads me to the concept of mitigation. So for all contracts, there is an implied duty of good faith and fair dealing. So if there is a way to reduce any damages caused by a triggering event like COVID-19, you have a duty to do so. You can't just ignore a problem if you have a way to fix it or reduce any further problems caused down the line by it. Next slide, please. Okay, on to how courts interpret some of these common triggering events. Obviously, epidemic or pandemic is likely to apply in the case of COVID-19. So if that's the language in the force majeure clause, you might be doing pretty good. Next slide, please. Acts of God is another super common term. Unfortunately, no Minnesota court, or really many other courts in other states for that matter, have interpreted this term under a force majeure clause. So in other instances, like insurance, an act of God is typically limited to natural disasters like earthquakes or hurricanes or floods. So while it's probably still worth arguing COVID-19 was an act of God, there really is no way to predict how courts are going to interpret the term in this context. Next slide, please. Another triggering event you might see is a national or regional emergency. So as you know, President Trump declared COVID-19 a national emergency, as well as Governor Walz. And as far as I've checked, those declarations are still good. And the key for using this as a triggering event will be causation. So did the emergency of COVID-19 cause your business to be unable to perform? Next slide, please. And the last triggering event I'd like to cover is the government action or order. So again, we are faced with that pesky causation requirement. So did the action or order due to COVID-19 prevent you from performing? Next slide, please. So how does the government action or order apply to COVID-19? An example of this would probably be a government order for non-essential businesses to shut down. If your business wasn't allowed to operate, it may have prevented you from fulfilling your duties under a contract. Next slide, please. Finally, some force majeure tips. It is critical that you pay attention to any possible notice provisions. Usually they'll be at the end of the clause, and they'll say something like, you must notify the other party within, say, 60 days that you're going to use the force majeure clause. If you don't notify them in time, you may have forfeited your ability to rely on this clause. Number 2, you should also make sure you're taking any reasonable steps to mitigate, aka reduce damage. It is your duty to do so under the contract. And also, you should consider updating contractual language in light of COVID-19. So this includes when you're renegotiating the contracts at issue, or if you have any future contracts, you should ensure a similar event is covered in case this happens again. And remember, litigation is not the only solution. I know Joe talked about this, but make sure you're talking to the other parties. Don't be afraid to renegotiate terms. The worst the other party can really say is no, or you'll end up in litigation. So anticipate that there may still be a dispute. Force majeure clauses can be ambiguous, and contractual interpretation is what we like to call squishy in this area. So you may read the contract one way, while the other party can just as easily read it the other way. And with that, I turn it over to Shane.
And actually, I'm going to jump in again and just pause because I know we covered a lot of material. I also want to comment that I lost connection, so my meeting chat is blank. If while I was off the call, you uploaded a question into the chat bar, it would be great if you could retype that question for me so I can make sure that we address it. Okay, so John, I think I'll just turn to you and see if there's anything else on your mind or anything else that you want to add to this conversation about force majeure or anything else that Jennifer has covered. John, is there anything else that you wanted to add?
Yeah, thanks, Emily. I'm not sure you can see me, but I'm here. No, I think Jennifer and what Joanne answered added earlier, pulls us right along. I think we're doing a good job here. There's nothing I have to add at this point.
Okay, fantastic. Then Shane, I'll go ahead and turn it over to you.
Fantastic, thank you. I've also been having a little bit of connection issues, so hopefully it doesn't happen during the presentation, but if it does, I'll come back quickly. All right, so Jennifer just discussed the ways in which the duty to perform a contract may be excused due to the language of the contract, namely the force majeure clause. But what happens if you get to the litigation stage and your contract does not have a force majeure clause? Thankfully, you are not out of luck. Minnesota law permits several defenses to non-performance. This means that if you are sued by another party because you did not perform your obligations under a contract, you may use these legal defenses to avoid paying the other party damages. For our purposes, the most relevant defenses to non-performance are commercial impracticability and frustration of purpose. So first, I'll discuss commercial impracticability. Under the defense of commercial impracticability, the duty to perform a contract may be discharged when it becomes overly burdensome, extremely difficult, or exceedingly expensive. It's worth noting two things. First, the qualifying language, overly burdensome, extremely difficult, or exceedingly expensive. It doesn't say somewhat burdensome, somewhat difficult, or somewhat expensive. Second, it's also worth noting that this is not a complete defense. So even if COVID-19 is strongly affecting your business, the courts still expect you to perform to the best of your ability. So this may mean that you need to perform partially now or completely when the difficult economic conditions subside. Next slide. There are three general requirements to meet the standard for the defense of commercial impracticability. First, there must be a risk or event that neither party recognized when they signed the contract. And this occurs when they sign the contract. And second, both parties assume the event would not occur. And third, when the event occurred, it made the performance of the contract overly burdensome, extremely difficult, or exceedingly expensive. Next slide. Under Minnesota law, the courts assess a commercial impracticability defense by looking at the foreseeability of the event. Was the event foreseeable by the parties when they signed the contract? Courts excuse performance when the future event was not reasonably foreseeable by the parties when the contract was signed, but they do not excuse performance when the future event was reasonably foreseeable by the parties when the contract was signed. Next slide, please. To better explain this topic, I would like to give two scenarios. In both scenarios, we have two actors, a car manufacturer and a car dealer. In the first scenario, the manufacturer and the dealer enter into a contract. The contract states that the manufacturer will provide 100 cars to the dealer. The contract was signed on November 1st, 2019, and the delivery date is tomorrow. There is an issue. Due to COVID-19, the supply chain of goods has been decimated, and the manufacturer can't meet the deadline. If the manufacturer is sued by the dealer, the manufacturer can argue that the delivery of the cars was made commercially impracticable by COVID-19. And if the manufacturer is able to deliver, say, 50 cars to the dealer, the court may order such partial performance. The court may also allow the manufacturer to delay performance until the supply chain functions normally. In this case, the contract was signed prior to COVID-19, and COVID-19's effect on the supply chain was not reasonably foreseeable to either party. This is a prime example when commercial impracticability is a viable defense to non-performance. In the second scenario, we have the same two parties, a car manufacturer and a car dealer. The only difference is when the contract is signed. In the second scenario, the contract was signed the day after the World Health Organization declared a global pandemic. In this scenario, a car manufacturer could reasonably foresee the supply chain issues. So this would be a much weaker claim of commercial impracticability. Next slide, please. So what does and does not excuse performance under the defense of commercial impracticability? I'll first talk about what does not excuse performance. So first, if there is an increased cost to perform the contract, that does not excuse performance unless the increase in cost is due to some unforeseen future event. And second, a rise or collapse in the market does not excuse performance. The courts deem both of these events as foreseeable, and if the contracting parties want to excuse performance for either of these events, then they must do so in the contract. Next slide. Now, what are the events that excuse performance? Typically, these are extreme events like war, a shutdown of the supply chain, embargoes. For our purposes, there is a strong argument that government-issued stay-at-home orders and the COVID-19 pandemic are events which may excuse performance. The key to determine whether commercial impracticability is a good defense for your situation is by looking at two things. First, determine if the event was foreseeable by the contracting parties when they signed the contract. And second, determine if the event makes performance of the contract overly burdensome, extremely difficult, or exceedingly expensive. Next slide. And I will actually pause here if you have any questions.
All right, so I don't see any questions in the chat bar. If folks have, I'll just reiterate, if folks have questions, go ahead and put them in the chat bar and we'll have some time at the end to get to them. John or Joe, is there anything else that you'd like to add to what Shane just talked about in terms of commercial impracticability?
Yeah, I can just to reiterate a point that he mentioned, courts are generally going to want to uphold the contract as much as possible. They take a view, which I think is correct, that business owners and businesses enter into a whole array of unforeseen risks, or what we'd call, the legal distinction between unforeseen and foreseen is a little tricky to ride along that edge, right? Business owners are taking lots of risks. And so what you'll see when these cases actually go to formal litigation is that they're not easy. There's not bright line rules. There's usually some in between, and the court's going to do what it can to try to enforce the contract as much as possible. John, anything to add?
No, I think we're fine. That's good.
Great. Thanks for that, Joe. Shane, we'll go ahead and send it back to you.
Great. So the second way the duty to perform a contract may be excused is the defense of frustration of purpose. When an unforeseen event erodes the principal purpose of a contract, the defense of frustration of purpose may discharge the duty to perform. There are three general requirements to meet the standard for this defense. And first, like for commercial impracticability, the event must be unforeseen when the parties entered the contract, for instance, COVID-19. Second, the unforeseen event was not caused by the non-performing party. And third, the unforeseen event undermined the principal purpose of the contract. What is a principal purpose? It's basically the primary reason for entering a contract. And both parties understand that without this primary reason, the contract would make little sense. Next slide, please. Under Minnesota, the test is what I highlighted under the three requirements, but I'll just reiterate them again. So first, the party's principal purpose in making the contract is frustrated. Second, without the party's fault. And third, by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. I'd like to give an example that's actually a case, a famous English case that kind of established this rule of frustration of purpose. The case is Krell v. Henry, and it occurred in 1902 in England. In 1902, it had just been announced that Edward VII was going to be coronated as King of England. C.S. Henry wanted to watch the coronation procession, and he contracted with Krell to rent Krell's apartment. You see, Krell's apartment had a fantastic view to observe the coronation. After the two parties agreed to the contract, the coronation was called off because Edward VII had fallen ill. At this time, Henry still owed Krell money for the apartment. Henry refused to pay, and Krell sued Henry to recover the balance owed. The court ruled in favor of Henry, stating that Henry's principal purpose of signing the contract was to view the coronation, and therefore, when the coronation was called off, by no fault of Henry, Henry was excused from paying the remaining money to Krell. Next slide. So now that we have discussed, or actually, do you have any questions? Okay. So now that we have discussed the ways in which you can discharge your duty to perform, whether it be the actual contractual terms, like a force majeure clause, or affirmative defenses, such as frustration of purpose or commercial impracticability, we'd like to leave you with some concluding thoughts. We'll talk about some practical tips, some policy arguments, and resources. Next slide. The first practical tip is to look at the contract. If you're ever in a position where you feel like you cannot perform the obligations under the contract, then look at the language. Figure out what you agreed to perform and figure out what the other party agreed to perform. Also determine, was this an oral contract or was it a written contract? If the contract was an oral contract, is it enforceable? Next, also determine if there's any force majeure clause and look at the language of the force majeure clause. See if there's any words like acts of God, epidemics, or pandemics, or other language which aligns with current events. Next slide. The second practical tip is to document. If you cannot perform a contract or meet deadlines, document the reasons why. Include a timeline of government actions, for example, mandatory stay-at-home orders, and also detail throughout the process why you are not able to perform or why certain things are going to be delayed. This helps for both renegotiation and for litigation. For renegotiation, it helps orient the discussion towards the facts instead of emotions. Oftentimes, the non-breaching party, or the party who is performing the contract, will often be upset that the other party is not performing their end of the bargain. By documenting the reasons why you are unable to perform, it brings the discussion back towards the facts and the reasons for it instead of the emotions of the situation. And for litigation, it improves your chances of success and saves time and money. Oftentimes, litigation can take several years, and if you have to document it after the fact, that might be difficult and in some cases might be impossible. It's a lot better to document it as you go through this process. Next slide, please. The third practical tip is to communicate with counsel. If you get to the position where you are overwhelmed or cannot figure out your next step, meet with an attorney. At the end of the presentation, we will provide several resources if you're at this stage in the process. And if you are unable to afford an attorney, there's also some other resources. With your attorney, develop a strategy to address the contractual issues. Determine if renegotiation or litigation is the best route. And the timeline from the practical tip number 2 will better inform this discussion. Next slide. The fourth practical tip is communication and cooperation. I think as Joe kind of hinted at, this may be the most important practical tip for this situation, because we are experiencing unprecedented times, and to succeed, we need open discussions and problem-solving processes. As Joe mentioned, there has been an increased willingness to work together to reach an amicable solution. But remember, communication is key. Leaving the other party of the contract in the dark will worsen the situation. And as I mentioned before, it's best to use information and facts and not emotion. Also, cooperate. Try to find joint solutions. It's often cheaper and it's forward-looking. It both preserves relationships and it increases your reputation. Also, litigation is expensive. In few cases, reach trial. Oftentimes, the courts will make the two parties try to negotiate during the middle of a trial. And it's often better to try to go towards negotiation before ever getting to the litigation stage. Next slide. The last practical tip is other ways to discharge performance. If you're at the litigation stage and you do not have a force majeure clause in your contract, try to figure out if your performance can be discharged using an affirmative defense. These include commercial impracticability and frustration of purpose. Determine if the facts of your situation align with the standards for each of these legal defenses. Next slide, please.
So Shane, let's pause there because that's the end of the practical tips. And that was a lot of really good kind of practical information. Joe, I'm going to turn to you first and just see if there's anything else you want to add to sort of the stage you've already set in terms of like practical considerations or practice tips.
Joe's muted.
Oh,
Thanks, John. One thing I would add is as you look at your contracts, do not hone in on one particular provision. For example, if you see force majeure or some of the language like that, you need to look at the contract more broadly, because if you use that particular clause, say, for example, you are unable to perform and there's a provision that allows you to delay performance for a certain period of time, there might also be a termination provision that the other party can exercise somewhere else. So, implementing that doesn't necessarily make the other side give up their rights. Some contracts have a clause that says, if you give notice, 90 days prior written notice, you can terminate the contract. Well, if one party argues force majeure, the other party might just say, well, here's your 90 days notice. I don't want to delay it and do it later and pay you later. Let's just terminate it. So look at the contract, the holistic contract to understand the rights of the parties and refresh yourself on what you negotiated if you have something in writing. That's kind of one just practical tip, not to forget that there's other rights that the other party might be able to exercise. The other thing I just wanted to mention is as we go forward, it'll be interesting to see when we think about tests like what was foreseeable. You see that in a lot of legal doctrines. What was reasonably foreseeable? Well, I can't think of a time, even with avian bird flu and those types of things, where we've had these governmental orders shutting down virtually, entire nations, entire states, and outside of essential workers and such. Well, now we've had that now. So as you're entering into new contracts and thinking about the next step, you have to. I don't want to forget about that aspect and think about what if something similar were to happen 2 years from now or 3 years from now. So even if we pull out of this now, we're going to have recent history of these types of things happening, and how this affects your business or could affect your business is something we'd probably want to pay attention to.
That's really good. That's really good, helpful information. I think looking at it holistically is always good advice. And also that some of these standards are shifting and changing in real time. So thanks for that, Joe. John, was there anything else that you're thinking about in terms of practical tips?
No, I think the practical tip number 4 that Shane focused on is so important. Usually the other side of these contracts is having difficulties as well. And if you come at the situation from one of being, how can we work this out, as opposed to, I have a problem and you have to let me out. Usually there'll be at least an initial sensitive ear on the other side because the other side is having its own problems on various levels. So trying to work it out is usually the best step. May avoid using a lawyer at all, but if you need a lawyer to help, sort out the circumstances, we'll give you some resources. But typically, the throwing down the gauntlet or saying, I just can't perform, you're just going to have to sue me, doesn't end up in a good place.
Agreed. Joe and John, while you still have your cameras on, we do have a question from an attendee, and I'll just read it for you here. It says, Can a party rely on the defenses of commercial impracticability or frustration of purpose only when there's no force majeure clause? Or can a party rely on force majeure and also on commercial impracticability or frustration of purpose? One of you want to address that?
Well, usually a court, usually the doctrines of impracticability and frustration of purpose are applied when there's no force majeure clause. That doesn't mean that they're totally exclusive of each other, but oftentimes the court will say if you've developed a force majeure clause that you intended to cover the situations that would relieve you from liability or partially from liability, and may say if something else came up that you didn't intend for that to be covered. But it's not completely clear, but that's just my general understanding of it.
Yep, that makes sense. Joe, anything else you wanted to add?
No, I agree with that. I mean, what you'll see if you in fact, you can Google a lot of these words or cases, and even if you're trying to come up with ideas for how to resolve some of these situations. But what you'll see though is a lot of times folks that are trying to invoke these defenses will, if they have a force majeure clause, will say, we have this, we think it applies, even if it doesn't apply, these might apply. Now, whether the court buys it, that's a different argument. As John said, that they might look at it and say, the parties negotiated this type of provision and that was their intent. And if we look in the four corners of it, we believe that to be addressed or not addressed, but it's still tried and it's still worth, looking or considering it. And it almost always does. Now, what I've seen in a lot of cases that I've read on this particular topic is they lose their arguments on force majeure and then they end up losing the other ones as well. So oftentimes for similar reasons, like this was a business risk, that you could have foreseen. Just because it costs you more to deliver doesn't change, it won't let you implement force majeure. It won't let you implement impracticability. It's just, that's the way it is. So a lot of times the fact patterns negate any of these provisions from applying.
Yeah, that's a good point. It's also one of the reasons why as transactional attorneys, we work really hard to keep our clients out of litigation in the first place, because there's just a lot of uncertainty when it's so fact intensive and so fact heavy. And it's dependent on every judge's or whomever's making the decision, their interpretation of what happened and why. It can be kind of hard to predict the outcome. All right, well, we will have a little bit of time for questions. So if anybody else in the audience has some, please feel free to type them up in the chat bar. But Shane, I'll turn it back to you to talk about policy considerations.
Perfect, thank you. So the last thing I'd like to cover before we get to the resources is policy consideration. So these are broad topics that parties should consider in light of COVID-19 and its effect on contract enforcement. The first policy consideration is economic slowdown. If everyone stops performing their contracts due to COVID-19, then it will lead to a slowdown of the economy. This may have greater long-term effects on a business than the struggle of performing at this time. The second policy consideration is the encouragement of escaping risks versus insuring risks. At its heart, contracts set the obligations of each party, and they allocate certain risks of the bargain. If courts allow parties to discharge their duty to perform by way of a force majeure clause or affirmative defense, then it decreases the incentive for parties to insure against risk. And last, creating legal loopholes. If the courts start to broadly interpret force majeure clauses or the affirmative defenses, then it could hurt the value of contracts. Also, various courts will have different interpretation of these issues. If one court states that a pandemic is an act of God under a force majeure clause, and another court determines that a pandemic is not an act of God, this may open the door for litigants to do something called forum shopping. Forum shopping is where litigants sue in a particular state to increase their chance of a favorable court judgment. Next slide. So lastly, we would like to provide you with some resources for small businesses. Next slide. All of these resources will be provided in the handout, and if you would like to learn more information about them or if you need to use them as a resource. So the first one is Legal Course. Legal Corps is a nonprofit organization that provides free legal assistance in non-litigation matters to low-income individuals or owners of small businesses. And they provide brief advice sessions and they offer full representation assistance. Next slide. I will now turn it over to Joe to discuss resources Fredrikson and Byron offer.
Thanks, Shane. Obviously, I'm a resource if you want to call or reach out via email to discuss your particular situation. Obviously, feel free to do that. I can tell you pretty quickly whether or not it's it's something that you might be able to get pro bono assistance on, or something that the firm would handle for you, or give you just at least direction on your matter. The other thing I wanted to mention is that we have a legal clinic going that is designed to help businesses that are impacted by the riots. So a lot of businesses locally here have had damage or other issues as a result of the riots. And we have a clinic where you can get at least a free consultation and some direction. And there's a few ways listed in here on how to get a hold of someone in that. Of course, you can always call me as well, and I can get you pointed in the right direction. And then on the next slide, if you want to click through, we've also put together a list of just local community organizations that help various types of businesses. What we see from a law firm perspective is a lot of these types of, NDC, Neighborhood Development Center, for example, will give us a lot of leads on, hey, this person needs help with this type of situation. And there's various qualifications in terms of whether you can get pro bono or volunteer assistance. Sometimes it's income-based, sometimes it's ownership. What does the ownership group of the company look like? Those types of things. But these organizations provide a lot of resources to businesses and can get you helped up with legal assistance. And then they also have a lot of other resources like access to capital, whether it's helping get low interest rate loans or those types of things. So I wanted to point that out in case you're not aware, and some of these may apply to your businesses.
Thanks, Joe. And I'm smiling to myself that somehow in this slide deck we I forgot to mention, the University of Minnesota Law School also has a business law clinic. So we have two options, sort of similar to how Legal Corps run. One is a brief advice virtual meeting we're doing these days. It used to be in person and hopefully will be again. So those are, 30-minute or so consultations to just talk generally about what sort of legal issues are going on and get you kind of connected with legal resources. We also run a full representation clinic in the fall and in the spring semesters, where law students actually develop a scope of work and then assist the small business client with that scope of work over the course of the semester. I have just typed up my email address in the chat bar. So if you're interested in more information on either of those programs, you can email me directly and we can have that conversation. All right, so we are almost at an hour, but we still have some time left. I just wanted to make sure we do a final call for any additional questions from those of you in the audience. If you do have a question, go ahead and just type it up in the chat bar. I'm just going to give it one more minute to see if anyone's typing. All right, very good. It sounds like we have covered all the material and answered all the questions that have occurred to folks so far. So Mike, I'm going to go ahead and turn it back to you.
Thank you, Emily, and thank you to all the presenters and panels for this great information. Again, we'd like to let everybody know that there are resources out there for small business owners via SCORE and the Small Business Development Center. So please reach out to those if you need them. If you have general questions concerning any of our programs, you can reach us at minneapolis.mn@spa.gov. And again, thank you for everybody for attending and have a great day.